Appeals Division 1 is now in session.
Please be seated. This is the time set for oral argument in our cause number CR 2018-118086. Excuse me, it's CR23 004114. State of Arizona versus Ian Mitcham. Before we begin, Ms. Edelman, you've requested permission to present argument here today. Is she here?
Yes, Your Honor.
Okay, thank you. This court can't grant it. I know you've applied to present argument. We will let you argue, but if for some reason the State Bar of Arizona rejects it, your application, the consequences are yours, not ours.
Understood.
Okay?
Thank you, Your Honor.
Counsel, we've reviewed the briefs in this matter, all of them. We've conferenced this case today in conference. Both sides have 20 minutes to present their argument. I remind the state that if you want to reserve any rebuttal time, it's incumbent upon you to manage your time for that purpose. And would each attorney that approaches the podium to give remarks, if you'd please state your name and the party for whom you represent, and with that, we'll begin.
Good morning. May it please the court. I'm Nicholas Klingerman from the Maricopa County Attorney's Office, and with me at council table is Ryan Green. The United States Supreme Court has repeatedly said that in applying the attenuation doctrine, police should be put in the same, not a worse position than had no police error or misconduct occurred. If police have never developed Ian Mitcham's DNA profile in this case, his profile was uploaded into CODIS. CODIS would have reported a match to the previously unknown evidence from Allison Feldman's house. Every circuit court has upheld the constitutionality of CODIS. There would be no constitutional debate here. Suppressing Mitcham's DNA now puts the state in a worse position, not the same position, than had no claimed police error or misconduct occurred.
Mr. Killingman, I have some factual questions I need you to clarify for me, if you would, please. When Mr. Mitcham was arrested in 2015 for the DUI that is the subject of the initial blood draw, was he ever charged with that offense?
Judge, I believe he was, but it is not part of the record or the results of that charge are.
It was a misdemeanor, correct?
It was a misdemeanor, but that would have formed the basis for a subsequent aggravated DUI.
Okay. So that would have been a prior, or maybe you can.
Well, he had a subsequent aggravated DUI in 2016 that was also premised on him having his daughter in the car with him. But that blood draw, I believe, as well, that DUI also, I believe, was part of the basis for that his DUI's aggravated DUI charges in 2016.
Was the 2015 blood draw was it ever tested for alcohol content?
Yes, we've argued that it was. Now, I'm trying to think of the specific site.
You're arguing that it was DNA analyzed in 2022, but I'm correct?
Yes.
Or what, was it 2020, excuse me. But my question is more pedestrian.
Yeah.
Okay, there were two blood draws, two samples that were taken in 2015. Were either of those tested for alcohol content?
I believe one of those two samples was tested, the other one was not.
You believe, or does the record show that?
I think there's a scientific examination report that shows the results of that test that came back on May 14th of 2015.
Yes, it should have been. It's an exhibit to, it would be an exhibit, I will get the exact one in 1 minute.
So So the charges from the 2015 blood draw, you believe, does the record support that there was an actual result?
Yes, Judge, I believe, and going back to one of the exhibits that were attached at the trial court would have been the 2015 blood analysis from the DUI.
But I guess,
that there was BAC.
was Mr. Mitcham ultimately convicted, or did he plead guilty to the DUI offense? I think is Judge McMurdy's question.
And I don't believe we have that in the record as well, whether or not he was convicted or pled guilty to that offense.
Is it your opinion that the DNA analysis of the 2015 blood draw exceeded the scope of his consent to the blood draw?
No, it is not. And so his consent, well, I view it in two ways, I guess, Judge. And first, whether or not the consent really controlled after the BAC analysis came back. And I would say it was fruit of a crime. It's the evidence of DUI. And so whether his consent at that point was controlling or not, I don't think he had the same expectation of privacy in that blood draw. But to answer the second part of that question, I think the logical implication from the state's argument is if you do not have a reasonable expectation of privacy in a DNA profile that's been extracted and sequenced, then what if his consent had mattered? And I don't believe so.
But that's not what Mario W. said. Mario W. said you do have an expectation of privacy in a subsequent DNA analysis, correct?
Mario W. did make that holding. It said that is a second search that you have some reasonable expectation of privacy in. I believe that has been overruled by Maryland v. King. And specifically, and I'll point to the quote in King, that in quote, in addition, the processing of respondents' DNA samples, 13 CODIS loci, did not intrude on respondent's privacy in a way that would make his DNA identification unconstitutional.
But King doesn't analyze whether it's a search or not, or whether it's one search or two searches. King says if it's a search, it's reasonable. That's the way I read the case. Do you read it differently?
I guess there's two parts of King, and I agree, King didn't, well, first, yes, I agree, King did not analyze whether or not there was two searches. You had the first part of the decision was analyzing whether or not it intruded on a Fourth Amendment protected privacy interest to take a buccal swab of an arrestee, and the court said no, it did not, then balancing the interest of law enforcement and the public.
Well, they didn't say that taking a buccal swab wasn't an intrusion.
Well, they said it was an intrusion, but not a constitutionally protected intrusion.
Because there was probable cause to arrest.
Yes, and so in those scenarios, and then the second part of that analysis then was, I think the quote that I just gave is saying then sequencing the DNA profile did not intrude further on any protected constitutional privacy interest.
Well, what in King, weren't they looking at the process? And they're saying, okay, you arrest somebody for probable cause, and the process is then you can take a buccal swab, even though we know it's an intrusion, that would otherwise be violative of the Fourth Amendment, and that the subsequent testing with the process doesn't violate the Fourth Amendment. So we're looking at the process. There are two components, the intrusion of the buccal swab and the testing.
I actually, yes, I agree with that, Judge. There is two components, and I would say here, the process of extracting a DNA profile, sequencing it, and then matching it is no further privacy intrusion once police lawfully possess that evidence.
Well, I guess that's where I'm struggling, and you can help me, Mr. Klingman, is the consent, the reason they got the blood is because he consented, but his consent was specific to testing for alcohol and drugs, right?
Correct.
And he actually said afterwards, if you upload this in CODIS, I'm dead, or something to that effect.
I believe that discussion comes from the 2016 DUI investigation. So going back to 2015, I don't believe that statement comes from.
It wasn't part of
that consent form. So when you see him, in the video, so the evidence that you have on him making references to CODIS would come from the 2016 DUI arrest. So
Which resulted in the 2022 conviction? Is that the aggravated?
that is the aggravated DUI in 2022.
Okay.
Yes. So when you have, but to go back to your question and talking about, I guess, the process and whether or not it's scope of consent, and not setting aside the argument that saying once you identify alcohol in that blood, I think you have a reduced privacy interest. But I think it's no different than the fingerprint analogy that King uses, or a number of the other courts that are cited in the state's briefing. It's just as if the police had said, can we test this gun to see if it works, a prohibit possessor maybe, and he consented, that there would be any additional constitutional intrusion from dusting that gun from fingerprints and running them through APHIS. In the DNA analogy that's been reached by numerous courts, King referencing it, and I could point to their statement, the Supreme Court statement saying, quote, DNA, quote, it uses a different form of identification than a name or fingerprint, but its function is the same. And numerous other Supreme Courts, most recently the Iowa Supreme Court, Massachusetts, in the Arzola case that's cited in the state's briefing, Rayner from Maryland's highest court, and then Baylor from the California Court of Appeals, amongst others, have drawn that same analogy.
But in your gun example, if the crime it's given for is eventually just goes away, the police can't then still hold on to the gun for 3 years and decide to test it for something else later on, can they?
Well, I think there's a number of cases that are directly analogous to those circumstances that have come up and in the DNA context, and courts have said yes, absolutely. And the two from briefing that I could point to is Baylor from the California Court of Appeals and Emerson from the Ohio Supreme Court. In both those two cases, the argument is that the DNA should have been suppressed from or expunged from the DNA databases. First one because there was legal error in obtaining the sample. There was no proof that was supported by probable cause, which the California court said that went away. Despite that, both courts said that you had no reasonable expectation of privacy anymore, and your DNA profile being used in an unrelated case. Functionally,
If we read Mario W. as saying there are two searches involved with DNA, there's the extraction and then there's the profiling, and we don't think Maryland v. King sufficiently overruled at least that portion of Mario W., how does the state prevail, at least on the issue of whether this was an unlawful search?
first in terms of Mario W., I'd say Mario W. never actually addresses whether a search warrant would be required in those circumstances. So I think that would still be an open question. I would argue in the context where police have lawfully possessed evidence of a crime that still does not infringe on a reasonable expectation of privacy that requires a search warrant. So Mario W.'s conclusion on that second search does not actually address whether that requires a search warrant. It simply held that once the person absconds, you could extract and sequence that profile. And so that's the first part of the answer. The second part, I believe, then the state would fall back and say independent source and inevitable discovery doctrines would apply in this case.
Is that based on the buccal swab that was secured at the time of arrest, or the convictions that happened in 2022?
I think so. There's probably multiple ways of getting there here, and I would lay out three. I think the primary, the most compelling one, is the convictions that happened in 2022. They're independent of this homicide charge and any of the DNA evidence obtained in the homicide charge. And now, because DNA is immutable, DNA evidence is fungible, DPS has not taken a new sample because of his convictions and uploaded the same profile into the DNA database. But ultimately, if it was a technicality of you have to expunge that sample, now pursuant to 13-1610, take new samples and re-enter them into the DNA database, we know the result is the same. I would argue that's the same type of technical constitutional violation or technical reversal that Article 6, Section 27 says this court shouldn't do. But setting that aside, I think the other two reasons would then be that the search warrant for the buccal swab that police obtained, if you excise out any of the evidence related to the 2015 blood sample and DNA extraction, probable cause would still exist within that search warrant
Why?
as well.
Because he's a male Mitcham and he lives in Scottsdale?
Well, you have a crime scene with evidence of a crime that's covered with bleach. There's blood. There's blood evidence. It's a homicide scene that he does have a familial match to DNA. I think that is pretty compelling evidence. And the police observed Mitcham driving in his Mustang, seeing him driving at his house, closely related in proximity to the offense. I think that is probable cause to get a buccal swab for a DNA identification.
Was there there wasn't an arrest warrant that was issued? In looking at Judge Whitehead's order, it's unclear to me if there was an arrest warrant issued for Mr. Mitcham, or whether there was just a search warrant and then he was arrested afterwards.
And then the buccal swab taken.
Correct.
Correct.
Is that how it happened? There was not an actual arrest warrant.
I don't believe there was an arrest warrant here. It's not part of the record, Judge, so I don't have it to reference for you to say that he was or was not arrested pursuant to warrant.
Okay, so he was just, it's your understanding from the record that he was just arrested pursuant to the statutory authority based on probable cause?
Yes. And with that, I would like to reserve remaining time.
All right, thank you. We'll now hear from counsel for Ms.
Good morning, Your Honors. May it please the Court. Marta Barco Penunuri from the Office of the Public Defender on behalf of Ian Mitcham. I will be reserving approximately 5 minutes of my time for Vera Edelman, who is here appearing on behalf of Amici ACLU and the ACLU of Arizona. Consenting to a blood draw for the limited purpose of a DUI investigation does not eradicate a person's expectation of privacy in their DNA material. This court should affirm the trial court's ruling for 3 reasons. First, the trial court correctly held that law enforcement exceeded the scope of Ian Mitcham's consent when they extracted DNA from his profile. Second, there are no exceptions under the warrant requirement or under the exclusionary rule that would warrant the admission of this evidence. And third, both the Arizona and federal constitutions mandate exclusion in cases such as this, where law enforcement exhibited a deliberate disregard for a person's Fourth Amendment rights.
All right, well, let's start back on some of the factual questions we were asking counsel for the state. In 2015, he was arrested, consented to a blood draw, and was that tested? The blood tested at that time?
Yes, it was, Your Honor. It was tested, and that would Exhibit 3 in the record of appeal that was submitted would show that that was tested for the blood alcohol concentration. Back
Okay,
in
was he ever
2015.
charged with a crime for that?
He was, Your Honor, and he eventually pled. It was a misdemeanor offense.
All right, so there's
He
no...
pled?
He did plead to that, yes.
All right, so once he pled guilty, isn't the blood become the evidence of a crime?
For purposes of the DUI investigation, Your Honor, yes, I would agree. Not for purposes of the DNA extraction. And even in cases where police is in lawful possession of evidence of the crime, it doesn't give them the unfettered discretion to do what they want with that evidence. And Riley versus California is a great example of that, where the Supreme Court of the United States held that just because law enforcement was in possession of a cell phone did not give them the authority to then search that phone without first obtaining a
Was
warrant.
the cell phone the evidence of a crime?
They believed it was evidence of a crime, Your Honor, yes.
But it wasn't after conviction. Was Riley before, that was before conviction?
That would have been pre-conviction, yes. But going back,
So you have evidence of a crime, and the state can't just test whatever they want? We're not talking about where they've just seized something. You've just admitted that blood draw had evidence of a crime. So wasn't this evidence of a crime in their lawful possession?
I don't believe so, Your Honor. I disagree with that. Had Mr. Mitcham not consented to the blood draw, law enforcement would have been required to obtain a warrant.
So if they'd gotten a warrant for the drugs and alcohol content, and I'm assuming they would have gotten it, since he pled guilty to the charge, then they would have had that sample in their possession anyway, so they still would have had evidence of a crime.
They would have had that sample in their possession anyway, but that would exceed the scope of the consent that Mr. Mitcham gave for purposes of that DUI investigation, Your Honor. In Florida versus Jimeno, the Supreme Court of the United States held that the standard for measuring the scope of a person's consent is one of objective reasonableness. What would that person have understood by their exchange with law enforcement? They go on to say that the scope of the search is generally defined by its expressed object. The expressed object in this case, according to the terms of the admin per se, was the blood alcohol concentration and or drug content. By signing the admin per se, what Ian Mitcham authorized law enforcement to do was to take that blood and then use that blood to test it for purposes of alcohol and or drugs. Nothing more. Yet the state is asking this court to...
Is it correct that the statement, if you put this in CODIS, I'm dead, or whatever it was, was that related to the 2015 blood draw or the DUA in 2016?
That was not, Your Honor, not the 2015, it would be the 2016.
Okay. So when you believe that there is not probable cause for the arrest of Mr. Mitcham in 2020, and why not? Even if you exclude the DNA analysis from the 2015 blood draw, what probable cause is lacking in the 2020 arrest of Mr. Mitcham?
Well, in several things, Your Honor. In looking at the evidentiary record, first, the state failed to admit that search warrant affidavit. So there was no way for the court, pursuant to State v. Ontiveros-Loya, where the Court of Appeals found that the trial court abused its discretion in applying the inevitable discovery doctrine because it was a state...
Okay, you're not answering my question. My question was, at the time of arrest, based on the information that was testified to at the suppression hearing, what probable cause was lacking? What did they need to know that they didn't know at the time of arrest?
They needed additional information, Your Honor. At that point, they had the familial DNA letter, which potentially linked Mr. Mitcham, but would also include his other two siblings that were out of custody.
And out of state, right?
And one of them was out of state. The other lived with Mr. Mitcham. Additionally, the familial DNA testing letter, provides a notice to law enforcement that there are instances where the source may not be related to in this case, it would have been Mark Mitcham, his brother who was in DOC. So there are instances where they may not necessarily be related.
Well, a familial DNA report in 2018 isn't going to tell you where the male Mitchams were at the time of the crime, right?
I'm sorry, Your Honor, I didn't hear the full question.
A familial DNA report in 2018 is not going to tell you where male Mitchams were located at the time of the crime.
That's correct, Your Honor. And what's concerning about that is that the focus then turns solely on Ian because of this blood vial. They never, there's testimony that they never started following his brother, who also lived with him, and at that point...
Did they live with him in 2015 at the time of the crime?
Yes, Your Honor. They were living at the time of the offense together. And
so it sounds to me like you have probable cause for both brothers. They could have arrested both brothers and tested them for DNA.
They could have potentially arrested the brothers and tested them for DNA, but that's...
So why can't they just arrest one of them?
At that point, Your Honor, I think that the problem is that they're focusing their attention on Mr. Mitcham because of this evidence that they have in their hands. And that's problematic because, again, all brothers at that point of the investigation could have equally been a match. And it doesn't excuse the state's failure to obtain a warrant in the first place, as our Supreme Court held in Brown versus McLennan. What law enforcement should have done is obtain a warrant and then test whether it was just Mr. Mitcham or Mr. Mitcham and all his brothers. And
switching gears a bit, do you agree that Maryland v. King overruled the two-search conclusion in Mario W.?
I
don't. I thought that'd probably be your answer. Why not?
I don't believe that it overruled Mario v. W. I think to not the two-step conclusion. I think to the extent that Mario was overruled, it would be to the it would be only to the extent that the subsequent extraction and analysis would have been considered a minimal intrusion, because there was a statute in place that allowed law enforcement to then take the DNA when a person is arrested for a serious offense. So under those circumstances, which are not present in this case, that's to the extent that I think King would have overruled Mario.
And if I agree with you, and we have two searches, even though I might disagree with Mario W., I'm a Court of Appeals judge, I'm bound by it. If I agree with you, then we have a search. And if you have a search, you normally need a warrant unless you have an exception. Is there an evidence of another crime exception to the warrant requirement?
I don't believe for this purposes, no, Your Honor. Again, I would go back to Riley on that. Law enforcement should have obtained a warrant. They were looking for information.
Do you have a case, though, where a conviction had occurred and then the search happened related to a different crime?
I don't, Your Honor.
Okay.
With respect to some of the cases that the state brought up earlier, Baylor, I would point that in Baylor, the DNA evidence was collected for a previous rape investigation, so that's why law enforcement was in possession of that. Law enforcement could not have collected the DNA legally pursuant to a statute as a result of the 2015 misdemeanor DUI arrest. With respect to Amerson, that dealt with probationers who had a reduced expectation of privacy, and Mr. Mitcham was a free man at the time of the search. So those cases are not applicable.
Let's say I think Mario W. was overruled by Maryland v. King, and we're writing on a blank slate in terms of reasonable expectation of privacy. What sorts of things should I look to determine whether there's a reasonable expectation here?
The things that you should look for, and this was premised in King and the various federal circuit cases at Whitekirk, Emerson, and Mitchell that have found that we have a privacy interest in DNA, is the fact that
One thing I can, sorry to interrupt, one thing I can look at is statutes, even in other areas of the law, maybe dealing with how private parties treat DNA. Are there other statutes that you can cite to in Arizona that say that there's some sort of privacy right to DNA that's in blood?
I think 13610 is inherent in that view, Your Honor, in that we do have a privacy interest in DNA, because otherwise why have the Federal DNA Act and statutes like 13610 that authorize law enforcement to collect DNA from certain category of people such as convicted felons.
And arrestees.
Certain arrestees. Our specific statute doesn't allow for just any arrestee to have their DNA collected. It's specific to...
But it would have covered Mr. Mitcham.
Not at the time of the search, Your Honor.
At the time of arrest for the buccal swab in 2020, it would have covered him if we eliminate the taint, right?
Mr. Mitcham was, I may have to clarify the facts. So Mr. Mitcham was arrested back in 2018.
For this offense?
For the homicide, correct.
Okay.
The DUI had happened in 2015. He then gets arrested in 2018. At that time of the 2018 arrest, he had the other felony cases pending, and then he was subsequently convicted in 2020.
I misspoke. So in the 2018 arrest, it would have 610 would have covered it as long as there's probable cause.
To collect DNA pursuant to the homicide, correct. However, the DNA that was collected pursuant to the search warrant related to the homicide investigation was premised on the unlawfully obtained DNA results from the 2015 investigation. After they received those results, it was not until they had those results that law enforcement then procured the search warrant and used those actual test results from the DUI investigation to support their probable cause on the homicide. And to go back to the other things that this court can consider, in addition to, so again, the federal cases in King, they were premised on federal statutes, the Federal DNA Act, that would allow for the collection and processing of DNA from a certain category of individuals.
How about Arizona Rule of Criminal Procedure 15, which I think the state relies upon to say this sort of thing, it happens?
And that takes us back to, like, that's something they could have done, but didn't. And so under Brown versus
Right,
McClellan.
but doesn't that cut against your argument, even if they didn't do it here, it cuts against your argument that there's a reasonable expectation of privacy, doesn't? It's an example of a positive law that allows this thing to happen under certain situations.
I don't believe so, Your Honor, because I think it still requires court intervention. And that's what's lacking in this case. There's no statute, there's no court intervention that provided the guardrails and the safety protections to ensure that law enforcement collected his DNA lawfully.
How about general law, like tort law and contract law? Is there anything in those areas that we can look to here? And I can tell you I did some research on what the law has said about whether you have a property interest in an organ or your blood, and there's several thousand years worth of precedent that say you don't. And most recently, Moore versus University of California from the California Supreme Court said you don't have a property interest and you can't bring a conversion claim because someone takes a body part and uses it in a way you weren't expecting.
I'm not familiar with this case, Your Honor. I think the most recent cases that provide insight into whether we have a privacy interest in our DNA would be cases such as King, Mario, Amerson, Wiechert, and those cases.
How do you get around his conviction? Because when he's convicted, you just told me that in 13610, once he's convicted of the two offense, the drug and the DUI offense,
So,
then his DNA would have been in CODIS anyway. Isn't that just an inevitable discovery?
no, I disagree, Your Honor.
I figured you would, but I want you to explain why.
Under the doctrine of inevitable discovery, it is not a doctrine that is premised it's not premised on speculation.
It's not. He pled guilty. He's convicted.
But the DNA has not yet been acquired, and if it ever is, then that would be analyzed under independent source, not under inevitable discovery.
I guess narrowing down on that, what is being speculated about then? If we're not speculating about the convictions, what is speculative? Whether the match would have actually occurred or the blood draw would have happened?
Several things, Your Honor. First, under the inevitable discovery doctrine, if applying that to Mr. Mitcham's felony convictions, the state would be, assuming if there was a hit, then that would require the state to then obtain a confirmatory DNA result and obtain a search warrant for that. And so this court would have to assume that that is going to happen. And even if the state does obtain a search warrant, then this court would then have to further speculate that that search warrant will in fact be granted. And those facts are not before us, and there's no way to ascertain that that in fact would happen. And even if a search warrant happens, then you have to presume that there's not going to be any issues with the test results. And that's precisely what Nix versus Williams rejected when it came to the inevitable discovery doctrine. It's all these layers of speculation that are problematic. And at this time, I'm going to turn it over to Ms. Eidelman. Thank you.
All right. Thank you, counsel.
Good morning, Your Honors, and may it please the Court. Thank you for allowing me to argue. I am Vera Edelman, appearing on behalf of amici ACLU and ACLU of Arizona. The state takes a startlingly broad position in this case, that it can genetically test any biological material in its possession without triggering the Fourth Amendment, and that argument rests on two faulty Fourth Amendment premises. The first is that collecting and analyzing DNA is not a search subject to Fourth Amendment scrutiny. And the second is that it doesn't matter how or why or subject to what restraints it collected or obtained the biological material to begin with. That second argument is enough to resolve this case. Mr. Mitcham clearly defined his consent in 2015, and the state clearly violated the scope of that consent in 2018 when it genetically tested his blood. But we also would ask you to reach the second question and hold that collecting and searching DNA does constitute a Fourth Amendment search, and it does require a warrant, because the state has made clear that it thinks it did nothing wrong here and would happily do it again. So to protect the privacy rights of all Arizonans, we ask you to hold that the non-consensual, warrantless testing of DNA is unconstitutional.
Has any court gone that far? If police follow somebody around and pick up their glass off a counter and test it, Is that a violation of the Fourth Amendment?
That isn't presented here. You don't have to reach the question of
I know it was a
abandonment.
hypothetical, but go ahead and give me your answer.
And your argument might implicate it someday.
I'm sorry.
And your argument might implicate it someday.
Correct.
Certainly, our argument would be that that is unconstitutional, that individuals don't voluntarily or knowingly discard their DNA when they take a sip from a water bottle or blow their nose in a Kleenex. And Carpenter would tell us that things that are not voluntarily let go of, that contain a wide breadth of private information, do require a warrant, do constitute a Fourth Amendment
Do you have any case that supports that? Because I read King, and I don't think King would get you there. So what case is out there that would support that argument?
I do think that King is important here because the first and relevant holding is that collection of DNA is a search. The reason that that opinion is as long as it is because they had to actually apply Fourth Amendment scrutiny. There, they held that all that mattered was reasonableness and not individualized suspicion because there was a whole large regulatory regime in place that removed all discretion from the individuals administering the buccal swabs, and the individuals who were engaged in that were not investigators that were ferreting out crime.
If one doesn't voluntarily shed their DNA, what are they doing? I'm involuntarily shedding my DNA into the microphone right now?
No, I think you have no choice but to release DNA into the air and expose all of the genetic material that's revealed there. It's very similar to Carpenter, where we have no choice but to, if anything, it's more obvious than Carpenter. Arguably, we do have a choice about whether or not to use a smartphone. We don't have a choice about whether or not to exist in a body that constantly sheds DNA everywhere that we go. And by the logic of Carpenter, which said that the breadth of the information that is revealed here, all of our propensities for medical conditions, our familial relationships, surprise parentage, unknown siblings, and the fact that we don't reveal that information voluntarily are essential in determining that we do have a reasonable expectation of privacy and that Fourth Amendment protects the information that is revealed through that search.
All right. Thank you, counsel, for your remarks. Mr. Klingerman, any final word?
Sure, and I just want to lead off on the last point, addressing whether or not voluntarily discarding DNA is the equivalent of cell site location information. I don't believe the DNA testing that was done here, or what's authorized in CODIS or the state's DNA database, allows anything other than for identification. So the data, the scope of data that law enforcement collects and provides, and is incentivized to only look for is identification purposes. You could go back to King and say that is no different than a fingerprint analysis. And the argument that DNA used for identification purposes is equivalent to cell site location information was just rejected a couple months ago by the Iowa Supreme Court in State v. Burns, which is cited in the state's reply to the amicus briefs. In terms of whether or not
Is there a post-conviction evidence of the crime exception to the warrant requirement? And if so, where do I find that?
I'm trying to think about how to phrase that. So whether or not if you were convicted of a crime and that would affect,
It seemed important to the U.S. Supreme Court in Maryland that if the individual wasn't actually convicted of the crime, he or she was acquitted, the state of Maryland would give them whatever back that they got under the statute. So to me, the fact that there's eventually a conviction is important in terms of whether you have a reasonable expectation of privacy or not.
And certainly, Judge, I guess that comes up. And I do point back to Baylor v. California saying your DNA should have been expunged. In that case, they said the first swab was taken without supporting probable cause. It was not authorized under the statute. It should not have existed in the database, and yet the California Court of Appeals came back and said the police already had it. You had no more reasonable expectation of privacy. I guess
What's the limiting principle, though, to that argument? If this happened 20 years after Mr. Mitcham had been arrested for the 2015 DUI, is that a search?
I believe there would be no limitation to that, no. And to go to your point, I think that has to do with, do you have that possessory interest? And you said looking at cases, Judge Callahan, and I would say, in the DNA context, courts have said no. Emerson, the Ohio Supreme Court, society does not recognize privacy interest and you do not have a possessory interest in your DNA. Barkley, the North Carolina Court of Appeals, that's cited in the state's briefing, once blood was drawn, defendant no longer had a possessory interest in that blood and DNA testing, infringed no privacy right. Baylor talked about the same concept as well.
That's all well and good, but that's not what Mario W. said, right?
Mario W. says that it is a second search, and it does implicate a privacy interest.
Right. So aren't we bound by that aspect of Mario W., even if King says something different as it relates to the process involved in the collection of an arrestee?
I think when you juxtapose Mario W. with King, that undoes that second search analysis, or the
Right. Well, you
scope
can
of
tell
that
the Arizona
privacy
Supreme
interest.
Court that when you get there. But for us,
Yes.
we can agree that maybe the process in King overrules Mario W. But they made it very clear, Justice Hurwitz made it very clear that in his opinion for the court, it was a second search.
And so if you disagree with the state's argument on the scope of King, then yes, you are bound by the Supreme Court's decision in Mario W.
The distinction, I guess, you would draw between the case, not to help you out, is that here we have evidence of a crime that he committed, versus in Mario W., you don't have evidence of a crime. You actually had just a buccal swab taken upon an arrestee.
Certainly, Judge, and I guess in answering that, I should have clarified, and I didn't want to repeat the previous argument, is that when your interest, your reasonable expectation of privacy is reduced in evidence of a crime, and Mario W. did not hold a warrant was even required for that second search in the pre-conviction phase. Certainly, and to go back to before I sat down, the argument is I don't believe Mario W. necessarily says that you needed a search warrant when balancing the interest in privacy against the cost-benefit analysis and allowing the search. Thank you, Judge.
All right. Thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course. The court's in recess.